All rise.
I want viewers watching my show to believe in themselves.
Judge Hatchett is compelling.
I was not the first one to throw a walk.
Let me just tell you what you just said.
Compassionate.
I really enjoy being a judge. Now I am touching people who I will never know I touched.
She's powerful.
You should have never let them walk out of your life when she was 3.
And she's on the bench.
Don't get me preaching up in here today.
Right.
You're watching The Verdict with Judge Hatchett. Seth Ballard is suing Brandy Manitti in.
Court is now in session with the Honorable Judge Hatchett presiding. Your Honor.
Thank you very much. Thank you so much. You may be seated. All right, we have a claim and a counterclaim. You have a claim against the defendant for $3,100 for work that you say that he did not pay you for. There's a counterclaim that you have for $10,000.
Yes.
There's a mechanics lien for $3,100 against the property that you own. And what's the balance of the $10,000?
Well, the rest of the money comes from legal fees. I'm now going to be considered default on my credit record possibly. So now my interest rate, if I wanted to get a new home, instead of being like 2%, might be 7 or 8% of my credit risk. And then just other fines I have to pay as well.
What kind of fines?
Well, obviously the $3,100 with the mechanic lien every time every day.
That's a big difference between $3,100 and $10,000. I'm just trying to understand.
No, you're absolutely right, Your Honor. Every day I don't pay every month. They back on more interest to everything. So.
All right. So let's start. Mr. Ballard, what happened and why are you suing the defendant?
Your Honor, I'm suing the defendant because, well, it's simple. First, I'd like to, talk about myself as a professional. As an electrical contractor, I've been doing this for 10 years. I've never had any unhappy clients until dealing with Mr. Manitti here. So
had you done work for the defendant before?
I have, Your Honor.
And were you satisfied the first time he did work for you?
Yes, Your Honor. 10 years ago, I gave him one of his first jobs after the hurricanes had hit Florida, before Hurricane Katrina hit New Orleans. I gave Mr. Ballard one of his first jobs because I believe in giving everyone a first chance. Everyone needs to start somewhere.
Right.
So he came up to me asking if I needed work, and I said, absolutely. I don't mind giving someone a chance, which is a great work. I have no complaints about 10 years ago work. No problem with that.
Yeah, but now we're here in court on opposite sides of the courtroom.
Yes, Your Honor.
And so 10 years later, you're doing work for him again. And what happened?
I am, Your Honor. He's trying to sell his house, and, at the buyer's request, they wanted an inspection done, a general inspection. So the only thing that really came out in his general inspection was a few minor to severe electrical issues throughout the house. So,
minor to severe?
Yes, Your Honor. There were multiple different things. There were 4 different tasks that needed to be completed about the house.
So 4 things.
Your Honor.
Yes, Your Honor.
Just to reiterate what Mr. Ballard's saying, the house actually was sold on contingency of passing inspection, which I pointed out the 4 issues that were wrong. I didn't hide anything. I showed up front what was wrong. I gave it to then Mr. Ballard to fix. And so everything else was already ready to go. It was a turnkey operation where it was sold as is. And me being the concerned citizen said, let me just take care of the issues so a new family that's coming in doesn't have to take care of these issues when they move in.
Okay, so there were 4 issues.
There were 4 issues
that needed to be taken care of. We can both agree on that.
Yes.
Yes, Your
4
Honor.
issues. So
before the inspection, Your Honor.
all right.
Before the
So
inspection.
I know that you have to have, the new homeowners want to have the house inspected.
Yes.
And you said, even though I'm selling this property as is, that there are 4 things that I know need to be corrected.
And which, again, I have no problem because I would not want that to happen to me. As in the golden rule, do unto others as unto yourself.
All right, so now we have these 4 items.
These 4 items,
and
yes.
what was the cost of repairing those 4 items?
For those 4 items, the way that we had the inspection itself done is when I had the estimate, those 4 items were for $650 with the agreement of $325 down to get this started, to get me, what I needed to get the work done. However...
And did the defendant pay the deposit of $325?
He did, Your Honor.
I actually insisted I give him half now, half later, as in good faith, and I know it costs money to actually start operations, so I had no problem paying the $325 up front.
And it's one of my policies, Your Honor.
All right, and so then what happens next?
So I do the inspection in the house. I go around and I find all these other things, minor problems. I see one outlet blown out in the kitchen, and then again in the bathroom. So I mean, for me, I'm taking a multimeter and I'm checking certain outlets, and I didn't check them all. I'm just checking a couple here and there.
Coming up on The Verdict with Judge Hatchett.
But what I did not know at the time is that I was going to need 64 of them, or 61 switches.
If you didn't know, how could the defendant possibly know?
And later,
I saw him repeatedly kicking Ramon very hard. I told for him to stop. He didn't stop until I had to raise my voice.
The Verdict with Judge Hatchett is back with the case of Seth Ballard, who is suing Brandon Manetti for $3,100.
The defendant paid you $325 as a deposit, yes?
Yes, Your Honor.
Yes. Then you went along and said, we've got A, B, C, D, F, G, and maybe a few other things.
Yes, Your Honor, because it's very important because the GFC eyes, what it does is it kicks off the electrical circuit if it detects, a human touch or any kind of water, for example.
Okay, so let's stop there. So you came up with a second list, not the 4, but a second list of items that you said, oh, these things need to be done too. Is that correct?
Yes, Your Honor.
Wait just a second.
Yes, Your Honor.
What was your agreement with the defendant? What did your agreement, did you have a written agreement with the defendant?
The only writing on the estimate, Your Honor, is it's noted here that, that these are other problems that needed to be addressed, that needed to be fixed. And, I mentioned how much each individual piece would cost. So, for example, if one outlet needed to be replaced, that's $20. If one GFCI inverter needed to be replaced, then that means $45. And what I didn't go over him with was how many of each one of these things we're going to need to replace, because at the time I didn't know. I'm only checking a couple of them during the initial inspection.
Wait. What did the agreement between the two of you say?
I noted it down, and this is probably where the bit of confusion comes in. I noted it down, and when I got the signature, I told him even then, I said, okay, I'll send you a revised invoice at the end of all this.
And, well, did you do that?
I did at the end of all this, which he signed the estimate, Your Honor.
But what did he sign? What did he sign and agree that the work to be done was to encompass?
Your Honor,
that's very important.
I have the paper right here if you'd like to look at it.
Well, let me see it.
Your Honor, in the meantime,
yes, sir.
I'd like to counter what this gentleman was saying. First of all, when we did the walkthrough for the 4 items, that was it. He did not notify me of any other work done. However, he did write in writing, again, I'm being truthful, he did write there could be other issues, not that he noticed while we were walking through and started testing. He did all this work after I was on vacation with my wife. So therefore, I think he pulled the old bait and switch. Oh, you only have these 4 things wrong?
Your Honor,
let me do another 128 additional fixings of a house.
Your Honor, if you see the picture of the plug there, from my professional standpoint looking at that, okay, if there's already 2 outlets burnt out like that, and usually that's because of, polarity. That's a polarity problem where 2 wires are backwards, and you don't really initially see these problems right away. They surface when you don't see them coming. In my mind, this was more of a safety issue. If he's selling the house, it's, really looking out for him. I've known this man for...
No, Mr. Ballard, that's not how it works. I want to see some authorization that you had authorization to do the next phase of the work. Do you understand what I'm saying?
I understand, Your Honor.
So where is that?
It was verbal, Your Honor. I mean, I've known the man for 10 years. Again, this was a rehire, and I've never had a problem with any other...
Wait. Why are we doing verbal when we have this wonderful, detailed outline work for the $650? How all of a sudden now did we get up to $3,100 and now it's just verbal?
Well,
what kind of sense does that make?
Your Honor, it was verbal in the sense that these are 4 issues that I'd have to address. Now, each one of these is going to cost $20 or $47. But what I did not know at the time is that I was going to need 64 of them, or 61 switches.
If you didn't know, how could the defendant possibly know?
He never called me until I got home a week later. Another week after my vacation, I get a bill for $3,100 additional.
Your Honor,
so there, as you can see, the old bait and switch and extortion all in the same time.
Your Honor.
So have you paid the $650?
No, man. I only paid $325 so far.
$325?
Yes,
which
ma'am.
I haven't even gotten that, Your Honor.
I beg your pardon?
The other $325, Your Honor. I haven't gotten that from even the original agreement on that
All
paper.
right. Well, you're getting ready to get that.
Which I have no problem paying because as work was done. However, I still need to obviously fix the other issues with the mechanics lien and everything
All right,
else.
let's talk about the counterclaim.
Yes, Your Honor.
All right, first of all, Mr. Ballard, you shouldn't have taken on that extra work. It doesn't work that way. And then now to then put a mechanics lien on his home and to cost him all the fees and all of that. So I am going to grant him on his counterclaim $1,000. You're going to get the mechanics lien resolved. You're going to go about your business. You're not going to have to pay the $325. And so you net a judgment of $675 on your counterclaim. And Mr. Ballard, this is a tough lesson. It should have been in writing before you did the second phase of the work. The plaintiff's claim is denied. Judgment, as I have outlined, in the interest of the defendant in the amount of $675. So ordered.
Judge Hatchett has ruled in favor of the defendant. The plaintiff has been ordered to pay $675.
I should have consulted you first before starting that work.
Sir, I appreciate it. I hope you learned your lesson and take care of that lien immediately.
Coming up,
I saw him repeatedly kicking Ramon very hard. I told for him to stop. He didn't stop until I had to raise my voice.
network featuring dynamic judges and live legal programming.
Well, we're not at your school, we're in my courtroom.
Unique court shows.
Where is any information about the company?
Live legal news.
That's what you should have done.
And a commitment to justice.
Either you tried or you did it.
The next generation of court programming in one dynamic network. Justice Central. You're watching Justice Central. Stay tuned. You're watching The Verdict with Judge Hatchett. Christine Bowl is suing Alan Rist in the amount of $389.95. Ms. Bowl claims Mr. Rist charged her for a uniform and 2 weeks worth of karate lessons, even though the defendant kicked her son out of the program. Mr. Rist claims the plaintiff's son's behavior was out of control, so he had to kick him out.
All right, Ms. Bowl, you're coming here and you are suing Mr. Rist for $389.95 to be exact. Is that correct?
Yes.
And that your son was enrolled in his school.
Yep.
So what happened?
My boyfriend's out of town, and he used to play with my son to...
I was teaching kicking moves in class, and I noticed that Xavier started repeatedly kicking a student by the name of Ramon in the ready stance. Now, when we get into ready stance, you're not allowed to strike your opponent. You have to wait until I say it's okay to. I saw him repeatedly kicking Ramon very hard. I told for him to stop. He didn't stop until I had to raise my voice. After that, I had a talk with Xavier. I also had a talk with Ms. Bull. I gave her a written report to sign and look over. She was surprisingly unapologetic.
What was your reaction?
I had talked with Xavier. We had a conversation. He said he was sorry. He was just doing what was said that they were practicing, what was authorized in the class. I didn't think there was a problem, and I did apologize. So,
Your Honor, she did not apologize.
Yes, I
in her
did.
own words, she said, boys being boys.
Coming up.
We immediately run out. We see Xavier there with Ramon again, and Ramon is actually on the floor clutching his right eye.
The Verdict with Judge Hatchett is back with the case of Christine Bowl, who is suing Alan Rist for $389.95.
Tell me about the second incident.
I was teaching a throwing move during the middle of class, and on this particular day, 2 of my instructors had called out sick. And there was a lot of students during this class, I think about 26, 27. So as I'm teaching this throwing move, I hear a loud commotion coming from the hallway. It sounded like shrieking. So me and the other instructor, we immediately run out. We see Xavier there with Ramon again, and Ramon is actually on the floor clutching his right eye, and he's crying pretty much at the top of his lungs. So
Wait. Why were those 2 students out in the hall when the class was going on.
They snuck out while I was teaching the throwing move. So I asked both kids what happened. Xavier told me that they were practicing punching moves, which is a big, huge no-no. So I had to have an emergency conversation with Miss Bull.
All right, and what happened in that conversation?
She was predominantly furious at me for the lack of supervision.
I would have pulled my child Xavier away from the class that day. This could have been totally avoided. They were outside the classroom. They both could have been killed.
You prepaid for
$300. It's about $150 a week. They're still charging my card, and he was only able to fulfill half part of that.
So she prepaid for 2 weeks.
Well, actually, she prepaid for about 6 weeks.
Okay.
And there were 2 weeks left.
Judge Hatchett's verdict when we return.
My gut is that there are some issues that are underlying Xavier's behavior, and 10 years old can be a very difficult time. And so, but perhaps the best solution right now might be to have him in counseling so that he has the ability to articulate some of his feelings as opposed to the physical acting out. Now, having said that, I am really concerned that there wasn't enough supervision in that classroom that day. I am not going to refund her the full amount because part of that is the uniform. But I think under these circumstances, we're going to split this in half. And so I'm going to award $150. I am hoping that you and your son will really seek the counseling that he needs. Having said that, I am entering judgment in favor of the plaintiff for $150. So ordered.
Judge Hatchett has ruled in favor of the plaintiff. The defendant has been ordered to pay $150.
I hope you hear what the judge says and have better supervision for your students.
I wish you and Xavier well, and like the judge said, I hope you enroll him in counseling.